Bismillahirrahmanirrahim. Assalamu alaikum. I am Dr. Javed Iqbal Khokhar, Professor of Forensic Medicine and Toxicology. As we are discussing the law related to medical men, and this is the 6th lecture of this series. And in this lecture, I will be discussing the law and medicine relationship. And the learning objective of this lecture will be that I will be discussing the relationship which the law and medicine exists, and what is criminal justice and what are its administrative commands. Then definition of crime and criminal responsibility, because we have to define the responsibility of a crime, so that we have to understand. Then what is mens rea and actus reus, and the composite of these two becomes the crime. Then we'll discuss the criminal procedures, and in this criminal procedure there are general criminal presumptions of the law, general exceptions of the law, and general definitions. And then finally there is the execution of justice, and which means the awarding the punishment. So starting with the topic, the law related to medical men, that is the law and medicine relationship. The relationship between law and the medicine is ancient, and both being the learned members of the society have intimate relationship, and both have common goals in their respective fields, and which are basically the pursuit of the truth, finding the truth for the service of the mankind, whether it's a client or a patient. For law, it's a client, and for medicine, it's a patient, and both are searching for the truth. And doctor and lawyers, both being the specialist in their fields, they help their client or the patient in this regards in their medical and legal problems. The medical practitioner should not refuse to become the witness in the administration of the justice, because it may prolong the legal proceeding, and the doctor being the technical member, its evidence is most important. And lawyers, they already interested only in their legal rights and using various tactics to delay the case. So doctor should not delay the case in avoiding the appearance before the court as witness. A good example is the word cause, and that means both professions use it, but they have got different meanings. For medicine, for example, in the case of cancer, the causative factors plays a different role in their part, and we are looking for the cause of the disease, whereas each factor has a definite role and has to be removed. Similarly, in law, in resolving various conflicts between the persons, it requires that the causal factor, that the cause be 51% responsible, because less than that, for example, 25% is not enough to hold the person responsible. Now, the criminal justice and its administrative commands. There are 3 administrative commands in the criminal justice, and they are substantive criminal law, substantive criminal law, criminal procedure, and execution of criminal justice. The substantive criminal law means that it is concerned with the definition of the crimes, because the criminal responsibility has to be fixed. The definition of the crime always contains some element of mind, that some mental element exists in each crime, and which manifests as intent, purpose, and design of the crime. Now the mens rea, it's a Latin phrase and it means the evil or the criminal intent, which is a prerequisite to guilt, and thus it is a condition which is precedent to the liability of a crime, that there is an evil intent or mens rea present before actual commissioning of the crime. Now the actus reus. So actus reus is actual commissioning of the crime causing the harmful results. The punishment of the crime is only awarded for the harmful results, and which is after the result of criminal intention. Thus, in addition to mens rea, there always has to be actus reus, that evil intent and actual commissioning of the crime results in crime. So, which is an action that indicates the implementation of the criminal intention. So, which is actus reus, and it represents the evil action. In the absence of either of the two, the crime cannot be considered as committed. So the mens rea, that is the evil intent, plus actus reus, that is the actual commissioning, will result in the crime. Now the criminal procedures. The criminal procedure is conducted in the criminal courts of law, and they have to fix the criminal responsibility. So keeping in mind, there are three essential components which should be looked for. That is general presumptions in the law, general exceptions in the law, and general legal definitions. Then what are general presumptions in the law? The general presumption in the law are that everyone is sane and is responsible for his action, and everyone is innocent until proved guilty. Similarly, at the end of the proceeding, if the court of criminal law is in any reasonable doubt about the allegation, then the case should be resolved in the favor of the accused, which means that the benefit of doubt will be given to the accused. Then the general exceptions in the law. There are three exceptions in the criminal proceeding, that are immaturity, insanity, and intoxication, which means that the accused must have acted voluntarily without any external influence, force, drug, or disease. For example, the explanation is that a child who is not sufficiently mature to understand the nature and the consequences of an action cannot be considered to be guilty, and an adult who is incapable of knowing the nature and consequences of an action due to unsoundness of mind cannot be considered guilty. Or an intoxicated individual shall also not be guilty, provided the administration of the intoxicant is without his knowledge and against his will. The execution of justice now will be the actual punishment. That is, after fixing the criminal responsibility, the punishment is awarded in accordance with the law. So this is whole criminal procedure, that you have to establish the criminal responsibility, and keeping in mind the general exceptions and general presumptions of the law, you have to fix the criminal responsibility. Then and then only you can award the punishment. So the summary of today's talk is that we have discussed what is the relationship of law and medicine, and what is criminal justice, and what are its administrative commands. We defined the crime, and we understood what is meant by criminal responsibility, because every crime has to be fixed for its responsibility. Then we also discussed the mens rea and actus reus, and the composite of these two is crime. This is a Latin phrase. We have understood mens rea is evil intent and actus reus is actual commissioning. We have also discussed the criminal procedure, and this is for the criminal proceeding in the law courts. There are general presumptions, general exceptions, and general legal definitions which have to be defined. And finally, there is execution of justice in awarding the punishment. So that's all for today. Thank you very much. Take care. Allah Hafiz.